R. Griffin, Judge, presiding over the second business sports court trial. Near your attention, you shall be heard. May God save the United States of America, the state of Florida, and this honorable court. Please be seated.
Good morning, everyone, and welcome to a session of oral argument in the 5th District Court of Appeal. As you've already heard, I'm Judge Griffin. To my right is Judge Orfinger, and to my left is Judge Cohen. We have both civil and criminal cases on the docket this morning. It's rather an abbreviated docket. As I'm sure you all know, the civil cases are the criminal cases are 15 minutes to decide, and the civil cases are 20. There's a clock on the podium, and I'll for you to keep your time, and if you'd like, I'll assist you with time reserved for rebuttal. We'll take the cases in the order they appear on the docket. The first one is Jones v. State. Counsel can come up and begin when you're ready. If you please.
Good morning. My name is Randy Hillman. I'm here today on behalf of the appellant, Matthew Jones. This particular case is a appeal basically from denial of the trial court's request to the trial court to withdraw a plea pursuant to a plea agreement.
Now that request is post-sentencing, correct?
Correct.
I'm somewhat concerned with the lack of an objection at the trial. As this is going on, you've got the state presenting witnesses that are saying very, negative things about your client, unflattering things about your client.
Right.
Wouldn't you have a duty to object at that point? And if you don't, isn't your burden then to show a manifest injustice?
Well, I would agree that it would have been better to object at the time of the sentencing. However, I raised 2 points in my appeal. One is basically that the state violated the plea agreement, and 2, ineffective assistance of counsel. And the issue that you raise is, I would say, number 1, we have a contract between the state of Florida and the defendant.
Well, would you agree, though, that absent the objection at the trial level, that when you get to a post-sentencing, that the burden is to show a manifest injustice?
No, I don't think so.
Okay.
I don't feel that.
You should read Lynn versus State and the appellate rule on this issue, because I think that if you do a little bit more research on it, you're going to find that is what your burden is.
All right. I understand what you're saying, and I realize that would be an issue in this case. But when you have 2 parties and they have a contract with each other, and this is what we have, is we have a contract between the 2 parties, and I cited a case in my briefs, State versus Simon. We have a contract, and when you're looking, and both parties agree we have a contract, all right, and both parties have a obligation, as I cite the cases, to deal fairly with each other in this case. And if you look at the other case, also Simon case cited in my brief, we have the state of Florida, and when you're dealing with the state of Florida, you think, well, I'm dealing with the state. This is not any old contract. This is the state of Florida. And you think certainly they're going to be fair with me. They're not going to be coming here and saying all these terrible things about me. And
but the evidence relative to the crime, certainly the trial judge could be informed as to the facts and circumstances of the offense. I think that was contemplated in the agreement that was entered into by the parties, and certainly in order to make a reasoned judgment in terms of a sentence, a trial court would need to know that. So the fact that there are unflattering things said about your client in the context of the offense, certainly that's not a problem, is it?
No, absolutely not. No problem whatsoever with that, none. But they went beyond that. I mean, they called my client a murderer. They called him a thief. They said the police...
A murderer in a context other than this crime.
Right. They said he had murdered somebody else. You know, why in the world... I mean, why in the world...
Well, it was the victim's sister that said that, correct?
No, it was the police officer. The police officer...
The detective said that?
The detective said, we have heard rumors that this fella is a murderer. Okay? We've heard, you know, we're investigating a drug dealing with this guy.
Well, but the meth lab really could be part and parcel of the offense, depending upon how the facts of the case are viewed. There's an argument made that the murder of the victim was precipitated by the fact that your client was involved in meth lab activity, and that the victim's sister had been a confidential informant, and that he was afraid that the victim was a confidential informant as well. I mean, there's some of that background here.
I don't think so, Judge. The evidence presented at the sentencing hearing was that the Christopher Carter, who was the murderer, was high at the time that he killed the individual involved, which was done without even any knowledge of my client. But I don't think there was any testimony that this alleged meth lab had anything whatsoever to do with this crime. I think that had absolutely nothing to do with it. And, you know, they said all these terrible things about him, and how in the world would my client, I mean, if he was going to enter this plea, and he was told, we're going to tell the judge you're a murderer, we're going to tell the judge that you run a meth lab, that everybody's scared to death of you, that you're a thief, we think, the police officer said, we think he wasn't truthful. But no basis for it.
Mr. Hillman, you said, and I believe correctly so, that the agreement between the state and the defendant is a contract.
Correct.
Can you, and I'm looking at it right now, tell me what provision of the contract you feel that the state breached?
I believe the provision that, and I cite case law in my brief.
Well, just point me to the contract, because if this is a breach of contract lawsuit, the first question I would say, well, we have a written contract, we interpret it according to its plain words. Just show me in the writing here what it is that the state did that they weren't supposed to do, or vice versa.
The contract says that they're supposed to inform the court of information regarding this particular offense, and they didn't just do that.
But what it says is, if Jones fulfills his obligations under this agreement, at the time of sentencing, the state will recommend the court take into consideration the cooperation of the defendant and will not recommend a specific sentence. Is that the provision that you think they breached?
I believe they breached the provision that says that they were to only, it doesn't say only, but they were only to, what Mr. Jones understood that they were going to tell the court.
Well, I'm not interested in what he understood. The basic rule of contract law is that we look at what the parties wrote down, not what they subjectively intended, but what they objectively wrote. And so I'm just trying to view this because you said, and I agree with you, that we have a written contract. And so I'm looking at it like a breach of contract, and I'm asking you to point out for me what provision of the contract you think the state breached.
Well,
or is your argument that there was some sort of an implied condition that wasn't set forth that was violated by the state?
yes, Judge. I think that one, they are only supposed to inform the court of circumstances around this offense. And number two, as I cite in my brief case law, which we state, is we have stated the implied covenant of good faith exists in virtually all contractual relationship. Every contract includes an implied covenant that the parties will perform in good faith. Every contract imposes upon each party a duty of good faith and fair dealing in its performance and its enforcement. And I also cite in my brief the Simon case, which is the courts have said we want people to do plea agreements. We want that. And what this has had will have a chilling effect on people ever entering into plea agreements. Even myself personally, in my own practice, now that I've seen this happen, I'm worried about a client ever entering into a plea agreement.
Oh, you need help with that? You get a cap.
Pardon me?
I'm just trying to help you. Get a cap.
Get a cap?
Get a cap.
Well,
Say, all right, our plea agreement is going to be, that they'll inform them of the cooperation with a cap of X.
certainly that would be one way to go. But when you have a plea agreement, why would anybody expect, when you enter a plea agreement, and you're dealing with the state of Florida, you're not just dealing with anybody off the street. I mean, wouldn't you think the state, if you look at the transcript...
Let me ask you this. Let's assume you have a homicide and you've got the victim's family. And the victim's family is unhappy with the terms of the agreement. They're unhappy that they let him plead to the counts that he pled to instead of charging him as a principal or accessory after the fact. Does the victim's family have a right to come in and tell the judge, we want the maximum sentence, we don't care what the prosecutor has agreed to or not agreed to, we want to tell you about the victim and we want to tell you about the effects of his loss on us. Is that state action?
No, that's fine.
Okay, so the sister could come in and say what she wants to say to the judge without there being any implication of a violation of the contract.
Well, I think that is, in my opinion, I think certainly she could come in and say, we think that he should get the max, no problem. But this is the state offering these witnesses. And in this case, we had two things. We had state witnesses saying terrible things about my client that had nothing to do with this charge. And then also the sister of the victim got up and said something. I think they should have said to her, this is not relevant in this case, that you think that this guy once was a member of a cult.
Oh, but if it's not state action, if the testimony of the sister isn't state action,
right,
then how is that a violation of the contract?
Well, first of all, it's the state that's
They can't stop her from elocution at the time of sentencing.
I agree, and I think I see that as a less strong argument when somebody else, it's a civilian, so to speak, offers it. But we didn't have that, only that in this case. We had a policeman getting up on the witness stand and saying things that just weren't true, had nothing to do with this case, and there would be no way in the world that this defendant or the attorney representing him would have any idea that the state would sink to this level. This is the state of Florida. And you would think, hey, listen, I just went out and helped them convict a murderer. Not convict a murderer, got a murderer to plead guilty. And if you read through the transcript of this whole sentencing proceeding, that was so minimized. It was almost like an afterthought that he had cooperated. If I was representing this gentleman at the trial level, I would expect...
You're down to 2 if you want to save him.
I would have expected the state to say, hey, and emphasize, my client cooperated. That's what I'd expected, instead of them concentrating on these things that had nothing to do with the case. And just one quick thing, that manifest injustice, which you raised at the very beginning. I read through the Simon case, which I quote, it never mentions one thing about manifest injustice.
Read Lynn versus State.
Pardon me?
Read Lynn versus State.
Thank you.
And there's an appellate rule on it as well.
May it please the court, my name is Pam Kohler. I represent the state of Florida on appeal. As far as he's talking about the officer calling him a murderer, it had to do with this case. He had heard some rumors that this guy had someone killed and that was put in a wood chipper, and it's clearly about this victim in this case.
Well, I'm not sure that was. And I tell you that I'm somewhat troubled by this. You make an agreement that says, we're not going to make any specific recommendation.
As to the number of years.
And then you go and throw the guy under the bus.
Well, I think...
there are ways to make recommendations, and then there are ways to make recommendations. It's, you can make a recommendation without actually saying, we recommend the maximum sentence. And you can do that by presenting all this testimony as to how bad this guy was and how atrocious, I forget the exact word, appalling, the facts of the case were, and this and that. And haven't you effectively, with a wink and a nod, told the judge you want the maximum sentence without actually using those words?
Well, number one...
Contrary to the terms of the contract.
I don't think... the state did what the state was required to do under this plea agreement. Number one, we were supposed to null process counts 1 and 2. Number two, we were supposed to make no recommendation. The plea agreement didn't say the state would remain silent.
You can make that recommendation implicitly. It doesn't have to be explicitly, Judge, we recommend 15 years. You can do that in other ways. By your presentation at sentencing, can't you effectively tell the judge in your presentation that you really are wanting the maximum sentence?
Well, I think it's clear when you read this transcript that this police officer is not happy with this plea agreement. And in fact, at page 27, the state of Florida basically says, well, you do know it's true that without this guy's cooperation, we would never have gotten the really bad guy, which is, Christopher Carter. We wouldn't have gotten his conviction.
That's taking something completely out of context. The whole tenor of this sentencing proceeding was throwing this guy under the bus by the prosecutor.
Well, I think it was the police officer throwing the guy under the bus by the police officer. I think that he clearly did not like this plea agreement. The state tried to get him back and basically say, you got to admit that without this guy's cooperation, we wouldn't have been here, basically. We wouldn't have Christopher Carter. He basically would refuse to even agree to that. He said, no, we wouldn't. We would have gotten there anyway. He refused to even accede that could not have happened but for this defendant, these defendants.
Who called him as a witness?
The state did call him as a witness. He was the first witness for the state.
Do you agree with the opposing counsel that every contract has an implied covenant of good faith?
Of course.
So your only disagreement here is that your contention is that the state didn't violate that covenant by bringing up the officer who you admit pretty much threw the guy under the bus. I concede that the state at one point tried to reel him back in a little bit, but he said what he said, and you all called him.
Right, and basically the state did make it clear to the judge, this man, without these three people's cooperation, not just this defendant, but the three of them, they would not have been able to get Christopher Carter. The judge did give the maximum, but he gave the maximum to both this defendant and Cheryl Carter.
I don't think that makes him feel any better.
Well, I think the point is that I think this judge was more moved, to be honest, by the victim's family's testimony, where basically the mother's like, we couldn't even identify our son. We couldn't even get DNA because of what this defendant and Cheryl Carter did to our son's body. And I think that's what the state's talking about when talking about how appalling this case is, that he said that they burned the body so badly, the DNA couldn't even be identified by the FBI lab. And I think that's what they're talking about as far as why it's so appalling. And it was appalling. The FBI couldn't even find any DNA on this body. The only way they identified this body is through the defendant's testimony.
But they made their deal.
True.
They wanted to get, the perpetrator, the person who actually committed the offense, and so they made a deal. And the question is, did they abide by the terms and conditions of that deal, and whether they did it in a good faith manner?
I think so. I think that at some point they did try to rein in this officer. One of the agreements, paragraph 12, I think the fact that there was no objection almost makes it seem like everybody was ready for this to happen, to be honest. And the fact that you had paragraph 12, which specifically allowed the judge to hear all the testimony, which both inculpated and exculpated the
All right,
defendant.
do you think that the testimony of the sister was related to this offense? Didn't
Yes.
that go well beyond that?
No, I mean, she basically got up there and she clearly, this is page 50 of this.
She talked about how he had gotten her addicted to methamphetamine. What was the relevancy of that as it related to this
Because
case?
she'd been addicted to methamphetamine, bought it from this defendant, she snitched on him. When this defendant allegedly learned that this victim, David Arsenault, was her brother, that's when he wanted him killed. That's the connection. And she clearly feels incredibly guilty that she's basically finding it's her fault that her brother was killed by this man. By Christopher Carter, who allegedly was the muscle for this defendant who ran a meth lab with the Mexicans. That's basically what the gist of that was. I mean, she clearly felt, and the state didn't ask any questions. They basically said, here's the sister, and she went on with her whole statement about how guilty she felt because she got hooked on meth and so forth. So, no, I mean, they all are talking about this case. They're clearly talking about this case.
Was there evidence presented that he had committed a prior murder?
No. I don't see where there was.
That
No.
insinuation wasn't...
I'm looking at page 9, after we talked to Timothy Winfrey for a bit, who was the guy who talked to the FBI, and the FBI notified, or DEA notified this officer, that we had heard rumors that Matt Jones didn't know anything about Christopher Carter, who's the one who actually killed the victim, that Matt Jones had someone killed and that he was put in a wood chipper. The implication is it's David Arsenault, that the body was put in a wood chipper and was dispersed over Signal Creek, was a rumor that we had heard, and we've been hearing this from our drug units. And so that's basically where they're coming from. This had to do with the drug deal, that David Arsenault apparently was an addict, which his family testified that he was an addict, and that he was trading basically stolen goods to the defendant for drugs. And as soon as Matt Jones found out that David Arsenault was the brother of Tracy, I can't remember her last name, who had basically snitched on him before, that's allegedly when he told Christopher Carter, his muscle man, get rid of him. And that's how this happened. So this is clearly, and allegedly a wood chipper was used to get rid of the body. And that I don't know, at some point they got scared because Christopher Carter was going to talk. They went and got the body, parts of the body, and they burned it. Down by the dog kennels, because Matt Jones would hear if the dogs would bark if anyone was messing around with the body down there. That's the gist of what was testified to. Nothing else about other crimes it was all related to this crime against this victim. If this court has no further questions, I'll rely on my brief. Thank you.
Thank you, counsel. Mr. Ullman, you have about a minute and a half left. You got something to say?
Sure. I just think the key thing that I want to emphasize is that we have a contract. Both parties had obligations under that contract. Mr. Jones fulfilled his obligation. He cooperated as he was required to do.
Again, I go back to my difficulty with that analysis is that there was no objection, and that changes the burden. I think if you look into it a little bit, I think you're going to ultimately agree that the burden changes. It becomes a manifest injustice burden.
I understand that, and I don't know, what is manifest injustice? Isn't it a manifest injustice to come to a sentencing and have the state violate a contract that you've signed? If they had an out. If they thought he didn't cooperate, they could have withdrawn the plea agreement, okay? They violated the contract. What are the consequences to them? And that's what the Simon case says. When you violate a plea agreement, there should be consequences. And I suggest to the court here, the consequences should be that he be allowed to withdraw his plea because they violated this agreement. And by them violating this agreement, there has to be some consequences. Why should they be allowed to violate agreement and then just get away with it? What are the consequences? There's obviously serious consequences to Mr. Jones? And what about the consequences of all other plea agreements in the future? Whenever I enter in a plea agreement now with this state attorney's office, I want something in there that says you will not present rumors, you will not present information that has absolutely nothing to do with this crime. I now want that in the plea agreement. And who would have ever thought that that's something you need to put in a plea agreement when you're entering a plea agreement with the state of Florida? I don't think anybody would have ever thought that. Thank you.
All right, thank you.
Thank you, counsel.